queen or another king.
Mark,
Yeah?
is there a copy of that
Yeah,
document
yeah, yeah, yeah.
somewhere?
Yeah.
On the website? On the
Yeah,
website?
I need to sort all of this stuff out. I'm not a good marketer. But yeah, it's all available on the website. So under the common law, and this here now is a generic thing. Okay, this applies to whatever claim it is. So under the common law precedents of the Earl of Oxford case 1615, partially legislatively codified in section 49 of the Senior Courts Act, the rules of equity prevail over the rules of the common law, and hence is admitted to be the highest legally enforceable rules in Her Majesty's Courts and Tribunal Services to publicly resolve disputes. So we're setting out the law and our respective duties and rights. Therefore, lawfully and legally and legislatively, everyone has the right to follow their conscience, which connects all of humanity as to what is right and wrong, i.e. causing harm, as equity is triggered by unconscionability, a wrong. So that's how we invoke equity and force the matter into equity. Equity acts in person, will not suffer wrong without a remedy, looks at substance and not form. And he who asserts must prove that right. Under the courts of rules of evidence, until somebody can bring the creator into the court, whatever you believe the creator to be, and it is self-evidence, all are equal under the law, hence what one can do, all can do, and no one's above the law, i.e. all are accountable for harm they cause. No one can knowingly impose their will upon another without free will, and free will is no mental coercion, which is fraud, no physical coercion, which is a crime against the person, and consent, which binds the parties then to the respective duties, rights and obligations. And all have a lawful excuse for right of self-defense to protect their mind and their body when under imminent attack by another using reasonable and proportionate force. Everyone is a beneficiary granted the mind, okay, by creation and a body, and no other has the right over that mind or body. What anybody chooses to do with their mind or body is each individual's absolute right and not subject to another's opinion. The creators of children, their parents, have an absolute right over their children until the children are abandoned or harmed or choose independence from the parents, including how they choose to educate them. Right, in the 1996 Education Act, a lot of people are starting to homeschool and they're getting hassled. Guess what? State schooling is one option of education.
Yeah.
Yes.
And then everyone has as a beneficiary has an equal entitlement to the benefit of creations from the grantor's seasonal fruits and natural resources. That's the res, or the trust property. Everyone as a beneficiary has an equal right to an equal amount of land, the trust property upon which to create the shelter from the environment. Everyone as a beneficiary has an equal entitlement to an amount of suitable land to provide for the nutrition and water to survive. Everyone as trustee has an obligation to apply humanity's best available knowledge so as to minimize damage to harm to the creator's creations for future generations who are the beneficiary. And everyone has the right to freedom of association, which ends where another's equal right starts. Everybody has the right to freedom of speech to allow the effective articulation of thoughts so as to not knowingly cause another harm. Everybody has the right to peaceful coexistence with fellow humans, and everybody has an obligation to keep the peace by not knowingly, i.e. following your due diligence, not causing another harm. Everybody has an obligation to force others uphold the peace so as to knowingly turn a blind eye is itself creating a breach of the peace. When disputes occur, all reasonable attempts must be made to resolve matters in private and keep the peace based upon natural justice. Before breaching another's peace, the person claiming that right must apply their mind to the evidence. When breaching another's peace, provide the respondent, the other person, with that evidence showing harm was done, intended to be done, or reasonably foreseeably done, and their required remedy to return to the peace. And the respondent must immediately cease their believed right and apply their mind to the evidence provided by the complainant and respond to the evidence on a point-by-point basis. And we'll look at what that point-by-point means. So essentially what you do is, if you look in the manual, I've got a point, sub-points, sub-sub-points, point, etc. Okay? The reason is, I want people to verify each thing. And if I'm wrong, you can just say, okay, point 9, point 1, you're wrong. And here's my counter evidence. At any page. All the manual, you'll see, all the numbering, everything is numbered. Okay? So the reason for that is that when we're making claims, you've got three choices. Is my point correct? If it's wrong, show me the evidence I'm wrong. And if you want further evidence for me to prove that point, ask me. So what we do is, if we've got an admission, a denial, admission, 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 we now no longer are disputing that, or that. So now we can concentrate our energies to deal with the issues where there's no agreement. This here is called narrowing the issues. Okay? And what happens is, if you put multiple points in one sentence, basically point 9 is partially admitted and partially denied. Gee, wow, you've achieved nothing. Okay? And that's why I use this point-by-point format, which is in the manuals. Anybody can send in and say, Mark, point 9 to A is wrong. And here's my evidence to say it's wrong. I can evaluate that evidence and then modify it or provide further evidence that, no, I don't believe it's wrong.
So just to recap, what you've put down here,
Yeah.
we can do that in notices.
Correct.
And let's say we're all equal under the law.
Yeah.
Obviously, they've got to admit that.
Admit it. Would they not bring the evidence to say
This
that
is
it's wrong?
brilliant.
So what was the
system is
third? You had deny, admit, and was there-
Admit, deny, or ask for further evidence. Prove your claim. Okay? I can't admit or deny it based upon the evidence represented. Okay?
Is there an option whereby we can say neither denied or admitted?
No. You have simple choice. How can you, I can't deny it or I can't admit it? Hey, what other choice is there?
Okay, is there a choice, I don't understand it?
Yes.
Yeah.
Give me more
That's why
evidence.
it's ridiculous.
Yeah. You know, I don't see any other possibilities. And in their own rules, this is what they say. You know, stood the test of time. It's a brilliant system. Absolutely brilliant. Okay, and the reason you want to narrow the issues is you don't want to waste the court's time. This is what the court's tell you to do, which is perfectly rational. At the end, if the claimant still believes they've been wronged, then you need to go to court. That's all it's okay, so in essence, what I've sort of read there, okay, is the summary. Okay, all are equal under the law. No one's above the law. All have an obligation to keep the peace, and all have the right to enforce the peace. And this is the system that we use. And so then I actually put in there the courts, my right to natural justice. Okay, I have the right of self-defense. All parties can request assistance from any of their choosing to assist them to defend themselves, i.e. making a direct attack on the Bar Association. What you're saying is, oh, I can only use your friends. No, up yours. I'm a king. I use who I want to defend myself. You've got no right to deny me that because I have the right of self-defense. And so then the public dispute resolution on natural justice must first determine the parties' respective duties, rights and obligations based upon the evidence before you, the neutral judge. The facts must be again based upon the evidence. What needs to be established in the court are the facts and the state of mind. And based upon that, the remedy that I want to return to peace. So that section sets out the contract between human beings. The next thing then is, what I'm doing is saying, okay, this is my beliefs. Now I'm going to show you in law how this is her standing.
Excuse me, Mark. You mentioned that you've got the right to defend yourself.
Yeah. However you feel fit.
Yeah. So could you get someone in to speak for you?
Correct.
Against
And
you?
they're denying us that right.
Power of attorney.
Yeah. We do that through a power of attorney.
There is a case for a lady who I want to take the case to court. I'm like her Mackenzie friend. She's definitely not mentally up for it. She's in bits.
It makes no difference.
So I've not issued the claim yet.
Yeah.
Can I issue the claim on her behalf?
Now this year I've got to find the procedure, but yes you do, because somewhere it'll be there, because you have the right that others keep the peace. Okay, I know in the Senior Courts Act anybody can intervene in a case, but I don't know if we're in the magistrates' court.
When you're filling in the actual
Well,
claim thing online, it tells you, are you the person claiming or are you claiming for someone else?
Yeah,
Ah,
therefore there
Just to
must
touch on
be.
your point, that you can, when you're doing it, you can, instead of paying the fee, you can apply for a government number to get the thing done for free. If you're on social services.
Okay, so it's there. This is why I say, until we find out all of these things which are important to us, it's very equitable. The problem is the bloody people. Yeah?
And when you say that you can't have anyone you want to defend yourself,
They say that.
no, that's the court system saying. So where do Mackenzie friends fit with that? 'Cause I thought
No,
anyone
what
could
they
take
do,
someone
okay,
in.
what they're trying to do, okay, and there is rationality behind it, okay. When you get people arguing crap, you're wasting the court's time, okay. And so what they've done is said, to avoid, because this is public expense, or it should be public expense, the courts, we want to minimize wasting public expense. And therefore, to stop people talking rubbish and wasting the court's time and the public money, we're going to give certain people a privilege to go through certain training, and they have duties, rights and obligations which go with that privilege to the rule of law and to the court.
So like the bar members.
Yeah.
Yeah.
Okay? So that way we stop wasting public resources. So there's a good reason behind it. Okay? However, at the end of the day, each person has the right of self-defense, therefore it's an option. It's not something they can enforce.
So you just have to say, well, Mr. Smith, here's my Mackenzie friend and he's coming in.
Okay, what we're doing is we're directly challenging this issue. Okay, so what we do is there's a power of attorney. You'll see it in the court order manual. We'll get to that. The power of attorney is saying, I want Rowan to talk on my behalf if I feel uncomfortable or need him or wish him to talk on my behalf. What's the problem? If you get a solicitor, you've still got to sign a power of attorney to grant him the right to speak for you. Okay? So what they're doing basically is tying one hand behind your back and saying you can only use our voice, our approved list. That goes against the statute of monopoly 1623. It goes against my right of self-defense.
All of these references, it's all in the
Yeah,
manual.
yeah,
isn't
yeah,
it? Thank
all
you.
this stuff.
Could I just ask something else quickly? I'm sorry, it's slightly
Yeah, no, that's fine.
but I had to do an interview under caution.
You had to do a
I had to do a voluntary interview under caution at these stages.
voluntary interview.
And they
yeah.
wouldn't let me take in anyone, like
Yeah.
a solicitor, unless it was a barman.
I have
Is
the
there
right
any
to
way
self-
around that?
Yeah, you've got the right of self-defense.
You can do it on your, yeah, I could go on my own. But if I wanted to take,
You should be allowed to take anybody you want.
Huh?
You should be able to take anybody that you want.
So how would you deal with that? Because they absolutely wouldn't, no way. They said you can have who you want in, but then we won't show you the evidence.
You have the right to remain silent.
Yeah,
Yeah,
no, I know
that
that,
right,
yeah.
but they wouldn't
Yeah.
show us the evidence.
Well,
And
if they're not showing you the evidence, they have no right to ask you to an interview.
yeah,
They've
but they
got no
wouldn't
right to
arrest
breach your
us.
peace.
How can you have to do a voluntary interview?
If you don't do a voluntary interview, they'll put out a warrant to
Yeah, they'll
bring
make
you
you
to do it.
volunteer.
Okay? But it's, this is the bullshit that
Yeah.
you just cut through.
Page
So is there
32.
any way you can get someone in with you, like a Mackenzie friend that's not part of their bar club?
It all depends. I mean, basically, quite simply from what you've described, okay, you've not shown me any evidence for your voluntary interview, therefore, bugger off.
Yeah, well, they're
If
saying
they issue
they'll
a
show
warrant-
you when you come in.
Yeah, but it's no good when I come in,
Yeah.
okay? I have no time to go through it. I'm not happy to come in and sit in your little thing without a coffee and a tea or putting my feet up with the music on whilst I go through what the claim is. Without a claim, bugger off.
That's an interesting point.
So
We're
you
not
can
allowed to
notice
waste
beforehand, yeah.
court's time.
Yeah.
Why should other people be allowed
Yes.
to impose on our time?
Absolutely.
And
Yeah.
is there a statute, an
And
actual
send them
statute that
invoice
backs
or
that up?
charge
No,
them.
it's the breach of peace, okay? And the law is very clear in the
Yeah.
breach of peace.
Yeah.
Before you
Price
breach
one,
somebody
send them
else's
invoice.
peace,
I've
you
done it
must
now.
show the evidence.
Yeah.
So if you want me to come to a voluntary interview or whatever interview, I don't care. If you do not show me any cause of action, a breach of a reason, okay, up yours.
It's equitable as well, isn't it?
Absolutely
Like
equitable.
Anne said, you can't waste the court's time, you
Yeah.
can't waste the police
Absolutely.
time. Why can the police waste your time?
Absolutely, yeah. But basically, this is what I say, all they've got is, you know, the monopoly of the use of violence, or legal use of violence. That's all they got.
Yeah.
Once you overcome that fear, you know what, like Liam said, you know, so what, lock me up, what do you want? Go ahead, put me in contempt of court. Okay?
Yeah.
So, okay,
Thank you. Sorry.
so basically, so the next part of the notice is backing it up with law and legislation. So the Oath Act 78 affirms, my word is my bond. Therefore, the social contract to govern is, will you govern according to our respective laws and customs? That's an offer of contract which was accepted with the words I solemnly promise so to do. It's a clear contract governance. So how on earth can the councils turn around and say consent's not required and there's nothing to do with contract? It's all contract. Then it goes through the governance, then the oath goes through to, before the Parliament can act, they make an oath to the monarch. As prescribed in the Parliamentary Oath Act 1866 and the Parliamentary and the Oath Act 1978. I swear by Almighty God, so this is what the MPs should be doing for us, and the Lords, okay, fall under the same obligations. So I swear by Almighty God, okay, and then it's an affirmation if they remove God, that I will be faithful and bear true allegiance to Her Majesty, Queen Elizabeth, her heirs, and successors. So now you know why they continue after the death of the Queen. According to law, so help me God. It's about law. It doesn't say about acts of parliament. Nothing. Okay? But that there is what that's the social contract. This is why I say we've got to hone in on these oaths, because that's the contract with the people. And so legislatively affirmed basically the first act of William and Mary creates the two houses, the House of Lords and the House of Commons, so it creates the legal fictions. Prior to that, the Lord died with the monarch. The new monarch cherry-picked what they wanted to take into their reign. Hence Magna Carta 1215 finished with the death of James I, but whoever took it over, Henry the whatever, decided to say, oh, hang on, I don't want Article 61, but I want Article 29, and I want this, that, the other. And that's called the reconfirmation of the charters. So the new king cherry-picked, this is what I want in my reign, I declare this now to be the law, and this dies with me. That ended with the Bill of Rights, because they created the legal fictions, the House of Parliament, the House of Lords, Parliament assembled, and acts of Parliament, therefore, are not related to the living, but it's given perpetual life, and until the MPs revoke it, it stands. So you cannot bind future generations, and you cannot be bound by past generations. So whatever in the past is unequitable, you just revoke. And you just carry through what's equitable. That's the theory of it. And then so basically I just go through the Bill of Rights. We went through most of this yesterday. But the Bill of Rights, I think really we should do as a separate thing. It's just fascinating. It's a brilliant document. Suffice to say that the Bill of Rights is a constituting authority. Therefore, you cannot change what created you. You can change what you create. Therefore, Parliament can modify and update what they do, but they can't create something greater than that. So they're trying to call the Human Rights Act, they're trying to rebrand the Human Rights Act as the Bill
A new
of
Bill of
Rights.
Rights.
How's that going? What's
I don't know,
the situation?
but that's done under the authority of the Bill of Rights 1688. It needs to comply with that. Okay,
So if they do rebrand it, it won't remove the original Bill of Rights, and
Correct.
that's still the superior
right. That's a
statute.
nice little marketing trick, isn't it?
But it's those who don't know what's going on.
Okay, now I want to read you something from the Parliamentary Archives.
Is that written down, or have we got to make notes?
No, that's in the. A lot of this overlaps, okay, from yesterday and when we go into the court auditor. Okay, so this was Betty Boudreau, you remember the old
Yeah.
80?
Yeah.
Okay, and this was in relation to parking fines stroke PCMs. Okay, and so she reminded the courts, okay, there has of course been no amendment to the Bill of Rights. The House is entitled to expect that the Bill of Rights will be fully respected by all those appearing before the courts. As you will be aware, the Bill of Rights is a constitutional statute and may not be repealed or applied. What you're saying is, or implying, is that it might be repealed expressly. Don't know. However, this was stated in the case of Thornburn versus Sunderland, which was the Metric Martyrs case, handed down by Lord Justice Laws and Justice Crane, and she quotes two passages from that. We should recognise a hierarchy of Acts of Parliament, as it were, ordinary statutes and constitutional statutes. The special status of constitutional statutes follows the special status of constitutional rights. Examples are the Bill of Rights. Ordinary statutes may impliedly be repealed. Constitutional statutes may not. Further, this was upheld by Lords Bingham, Scott and Steyn in an appeal which went to the House of Lords in Monday, 15th of July 2002. How can we be more clear? They know the Bill of Rights is a constitutional document which they cannot alter and must uphold and creates duties, rights and obligations.
They're saying it can't be impliedly changed, but that
They're
implies
implying
that
it
they
be
can
expressed,
expressly change.
which is wrong. They can't. Okay? But what they're saying is, courts uphold the Bill of Rights. We as Parliament are saying you must do it. We accepted it. Okay? So this was affirmed yesterday. We talked about the Boris Johnson prorogation judgment. It's all affirmed. Going back, we create the law in the independent judiciary, and that's how we control Parliament. Okay, and the Boris Johnson judgment totally affirms this. The lawfulness, the only judge is the courts, not Parliament. And the Act of Settlement 1700, legally, i.e. Parliament, we say the definition of the word law is your birthright. How can they dispute it? They can't. Okay? And that in the Bill of Rights is upheld with nothing can be done to the prejudice of the people. So it's really simple. I just don't get why they don't get it, or people don't get it.
Well, maybe
Money.
they do, but they don't want to admit it, and if you don't know what you...
Yeah, okay, now, this is the thing, in the courts, we've got to try and separate. So the one judge or magistrates turned around and said, but how else are the council going to provide the service? That's not an issue before the court, this is a court of law. That's a political question and has nothing to do with what's before the court. Okay? So we've got to separate out the facts from the rest. So basically, parliamentary sovereignty is just a load of crap. Parliament is sovereign, i.e. controls Her Majesty's government, the executive. We are sovereign as the people, as a collective, over all of it. But they just think that, oh well, because, you know, the majority voted, or this party got in, or whatever, you know, forget it. Each individual goes to the court to hold them to account. And that's what we're going for. And so once I've finished the by voluntary association, I'm going to do a PCP thing, because I think we're wasting our time with appeals. We just go and hammer them with private prosecutions.
Yeah.
So it's taking a rude while, but it's the only
They
rational
just
thing.
keep kicking them out anyway.
Yeah.
For every stupid speech.
Yeah.
I believe that all private criminal prosecutions must be dealt with at Westminster, is that right?
No, it depends, okay, it depends on the jurisdiction. So when we did Matt Hancock, that had to go, no one other than the highest magistrate in the country can deal with that.
If I want to do a private criminal prosecution against a local magistrate,
It may well be that the jurisdiction, okay, this is what the word jurisdiction means, that the magistrate in the local courts or the local courts do not have authority to deal with cases against magistrates. Therefore, that then maybe has to again go to London.
How do you know where it sort of goes?
They'll tell you. They'll direct it through. So Matt Hancock's basically relayed the information at Essex or whatever his county court is, and then that got moved from there to London. Okay. Now, basically the doctrine of Parliament sovereignty, again this comes from their own words in Parliament, okay, is the outcome of the battle between the Crown and Parliament as to who should yield supreme power. Okay, the supreme power to legislate rests with the Queen in Parliament by enacting, and the Queen is representing us, the people. So in theory, she should make sure that they're acting lawfully, and we wouldn't have this crap. Okay, so wherever we look, again, it supports that we, the people, are sovereign over the rest of it. So then it goes into the independent judiciary. In the notice, we'll be going through this in the court auditor manual. And then there's a section where you put in the details which are specific to your case. So all of this is generic and applies for anything. So basically what you need to do, in essence, what I'm trying to achieve with the template is you put your case number, and then you put the specific details of who you're serving. Now, we serve the individual because fictions can't act because they have no being. They act through its actors or officers. Okay, in companies it's directors, in the courts it's the judicial officers. So what we do is we use the magistrate's court name or the company name or the department name so that we can use notice to principal and notice to agent, get the dispute out to everybody, in theory, and then we hold individually the person to account. So what we would do is we say, magistrates, courts, you know, whatever, and Joe Bloggs, and acting as office of law, so that we're noticing the office as well, the legal fiction. Because when Joe Bloggs leaves, that notice is still applying to the whole office. So you need to be careful when you send it with making sure you're serving not Joe Bloggs CEO of, but Joe Bloggs and CEO and blah 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 company. Yeah?
What do you use if you don't have an actual court number where they've given you, say, a requisition number or a unique reference number?
You've got to find somebody to serve. Somebody must have created that paper, and so the councils are getting very shifty now. They don't like to give out names anymore. And so people are resorting to FOIs and DSRs and DSRs. Yeah?
There's a lady that I know that filed a notice thing against the CEO of, I think it was Northumbria Water or something,
Yeah.
Water Company. And then her case got thrown out because the court said the Crown Court, and she said, the judge said that it was not in the right jurisdiction, she should have served it to the company.
No.
So,
Okay,
what
go
would
back
be
to my
her
case.
remedy, yeah.
Go back to my case, okay? I went after the directors in person, but I was contracted with the company. So the proper way is you prove the breach against the company, and because it's a breach, a company can't act, therefore can't do anything unlawful, then the individual becomes liable.
So it's like two separate cases,
Yeah,
essentially. Yeah. And it should have gone to Chancery, could she have then brought it directly against the CEO, or would it still be like?
I mean, basically, I was trying to cut out the due process. So I first got to prove a breach against the company. That then means the officers are in breach because the company can't act, therefore their words acting as agents, because the company is in breach, it had no authority, therefore they cannot be acting under the authority of the company.